Good evening, Agile acquisition enthusiasts, and welcome back to the Underground Digital Tiki Bar. It is Friday night, and that means it's time for another episode of Agile Acquisitions and Alcohol. So cheers. All right, on tonight's episode, we are going to be talking about gratuitous software license agreements. Get your head out of the gutter. Okay, well actually more specifically we're going to be talking about whether or not a gratuitous license agreement is required when a vendor offers a free trial of software. This is an interesting question. It made even more interesting because really, quite frankly, there isn't case law, there isn't FAR provisions relating to this, and there really isn't any specific guidance. So what do we do with that? Well, as most people will say, if the FAR doesn't say you can't, it means you can. More specifically, FAR 1.102 says if a specific strategy, policy, practice, or procedure is in the best interest of the government and is not addressed by the FAR nor prohibited by law, statute, or case law, executive order, or other regulation, that the strategy, practice, policy, or procedure is a permissible exercise of authority. What does all that mean? It means if the FAR says you can't, you can. So, since the FAR does not specifically say we cannot accept free software for trial purposes, can we accept it? A lot of that depends, like most things. That's why we have contracting officers and lawyers to help us work through this. But on its most basic premise, let's think about the problem that we're trying to solve and the problem that we could potentially cause. So the big concern of the government accepting free anything is an Anti-Deficiency Act violation. So a lot of times you'll hear gratuitous agreements when it comes to planning parties or hosting events with regards to location and food and what can be provided and what can't. The gratuitous agreement is intended to ensure that when the government does accept services or goods that are intended to be free, that the vendor doesn't then come back and say, now that you've used this, you owe me all this money. And since that money wasn't appropriated, approved, committed, or obligated, you would now potentially have an Anti-Deficiency Act violation. That is no good. Go directly to jail. Do not pass go. Do not collect $200. In this particular case, however, especially if the company offers free trial licenses as a business practice, so anyone who wants their software can access the software on a trial basis, this is then essentially an understood end user license agreement. There is no method for the vendor to come back and ask for repayment. So when should we and when shouldn't we use free trial license agreements? Well, the government should not, by practice, use free anything for something that they would otherwise pay for or that for which funds have been appropriated to do. So in other words, you shouldn't use trial software license agreements to circumvent an actual requirement of the federal government. So when should you use it? Well, certainly for market research. In fact, FAR Part 10 is pretty explicit that the federal government should do market research to the greatest extent they can and to use all the measures at their disposal. Certainly, getting your hands on free trial software and working through it and seeing how well that software might work towards meeting your requirement seems to be appropriate and consistent with the FAR 10 intentions. Other concerns around accepting the free trials is, does it create a FAR Part 9 issue, an organizational conflict of interest? Have you somehow become biased by using free trial software before conducting a source selection? This one's a little bit touchy, but most likely the answer would be no. Hopefully, if you're using free trial software for the purposes of market research, you are using all of the free trial software at your disposal in that given market. So you're getting to experiment all of them equally. If certain companies don't provide that, then there's a couple of options that should be considered. Potentially reaching out to those companies, asking for a demo version of it or something that you can play with. Or just basically not factoring into your actual selection process your experience with the free trial software, but actually using the free trial software to build potentially a short list or to better understand what your own needs are. Kind of a swirly-twirly opinion there on free trial software. So to summarize it for you, free trial software can be used. It should be used for market research purposes or for just general experience to understand the capabilities that are out there in industry. It should not be used to circumvent a requirement that for which funds have been appropriated for. It should not be used for the purposes of making a final selection decision. If you have another process in place, that could be part of it potentially, but then it should be requested from all vendors. Okay, so pretty gratuitous. I hope you enjoyed this. If you did, give me a thumbs up. Feel free to leave a comment underneath. As always, remember to subscribe, and until next week, cheers.